Okay, sure. Good evening. I, Shivi Parihar, from National University of Study and Research in Raji, on behalf of the entire Think India team, extend a warm welcome to our esteemed guests and all participants as we gather here for the valedictorian ceremony of our 9th National Symposium on Landmark Judgments 2025. As we conclude this remarkable day, I reflect upon this enriching journey we have undertaken through the legal landscape of the preceding year. Throughout this symposium, we have engaged in profound discussions on landmark judgments that have significantly shaped our judicial framework. We began with an examination of the lawyer sounding case, where Senior Advocate Shri Siddharth Dave, Senior Advocate Shri A.S. Natkarni, and Senior Advocate Shri Vijay Hansarya provided valuable insights into this important matter. This was followed by an in-depth analysis of the Pragya Singh Thakur case, where perspectives shared by Advocate on Record Shri Arjun Ayush Anand and a Special Public Prosecutor of the National Investigation Agency, Shri Rahul Tyagi sir, were shared. Our afternoon deliberations focused on the judiciary 3-year practice case with Advocate Ms. Swati Gharial and Shri Mahendra Singh Solanki sir contributing on their expertise on the qualifications for judicial appointments. The day's discussions culminated with the exploration of the powers of Governor Presidential Reference Case, where Senior Advocate Shri Sanjay Ghosh and Shri Shravan Yamunar, a partner at Dental Links Legal, led us through the constitutional complexities surrounding gubernatorial powers. The deliberations held today have been intellectually stimulating, and the exchange of perspectives has truly enriched our understanding of these pivotal judicial precedents. As we approach the culmination of this extraordinary event, it is my honor to welcome the distinguished dignitaries who grace this valedictorian ceremony with their presence. With great respect and admiration, I would now like to have the honor of inviting Shri R. Ramani, Attorney General for India, Honorable Mr. Justice Sorab Banerjee, Judge Delhi High Court, Ms. Archana Partak Dave, Additional Solicitor General for India, and Shri Ashish Chauhanji, National Organizing Secretary of the Akhil Bharatiya Vidyarthi Parishad, and Shri Vijwal Mangal Punde, National Convener of Think India, to please join us on stage and take their seats. Let's welcome them with a warm round of applause. I would now like to have the honor of introducing you to our esteemed guest, Shri R. Ramani, Attorney General for India. He's a first-generation lawyer with over 4 decades of practice. Enrolling with the Bar Council of Tamil Nadu in July 1977, he moved to the Supreme Court of India in 1979, where he joined the chambers of Shri B.B. Rao. He established an independent practice in 1982 and was designated Senior Advocate of the Supreme Court in 1997. Over his extensive career, he has represented the union government, several state governments, universities, and public sector undertakings in major litigation. Notably, he served as a member of the Law Commission of India in 2010 and again in 2013. He was appointed as the 16th Attorney General of India on October 1st, 2022, and was reappointed for a further 2-year term in October 2025. Beyond his legal acumen in constitutional law, indirect taxes, and human rights, he's also a poet and an author. His literary works include Roses Without Thorns, a collection of poems, and the Supreme Court Practice and Procedure. He acted as the court receiver on the Amrapali Housing Project case and is deeply involved in academic activities, including engagements with the National Judicial Academy. Please join me in welcoming sir. I request Ms. Bhavya Rai from Arja Patiala to kindly felicitate sir. I would now like to have the honor to introduce you to our esteemed guest, Honorable Mr. Justice Sorab Banerjee, Judge at the Delhi High Court. Justice Banerjee was born on 20th January 1976 in Delhi. He pursued his law degree from the prestigious NLSIU Bangalore in 1998. After graduating from NLS, he enrolled as an advocate with the Bar Council of Delhi on 5th October 1998. During his illustrious career at the bar, Justice Banerjee practiced extensively in constitutional law, commercial law, taxation, arbitration, and service matters before the Supreme Court of India, Delhi High Court, and various tribunals. He appeared in several significant constitutional and legal matters, earning recognition for his acumen and advocacy skills. Justice Banerjee was elevated as an additional judge of the Delhi High Court on 11 January 2023 and was subsequently appointed as a permanent judge on 9 January 2024. His judgments reflect a deep commitment to justice, constitutional values, and the rule of law. Please join me in welcoming Honorable Mr. Justice Sorab Banerjee. I request Mr. Suraj Kumar Mishra from National Law University, Orissa, to felicitate Mr. Banerjee. I would now like to have the honor of introducing Ms. Archana Partak Davi, Additional Solicitor General for India. Ms. Archana Partak Davi began her litigation journey in 2003 after completing her LLB from University of Rajasthan, Jaipur, and thereafter LLM from Jai Narayan Vyas University in Jodhpur. She initially practiced as an advocate on record before the Supreme Court and was designated as a senior advocate by the Supreme Court on 19 January 2024. Subsequently, she was appointed as Additional Solicitor General of India with effect from 10th September 2024. She is the fifth woman ASG in the Honorable Supreme Court. With around 24 years of practice, she has handled major constitutional and criminal matters, representing the Union of India and also appearing for State of Gujarat. She has represented various PSUs, including Engineers India Limited, EPFO, and the Central Council of Indian Medicine. Ms. Davi has been involved in landmark cases, including the Permanent Commission for Women in the Indian Army, K.S. Puttaswamy on the right to privacy, and Prakash Singh versus the Union of India on police reforms. Her contributions have significantly shaped Indian constitutional jurisprudence. As ASG, she defends the union's interests before the Supreme Court in matters of national importance. Her professional rise from Rajasthan to the role of a leading law officer remains a strong inspiration for all young litigators. I request Mr. Aryan Ranjan from National University of Study and Research in Law to come forward and felicitate Ms. Davi. Now, I would like to have the honor of introducing Shri Ashish Chauhanji. Shri Ashish Chauhanji is the National Organizing Secretary of Akhil Bharatiya Vidyarthi Parishad. He was formerly the National General Secretary of ABVP and convener of Think India, a platform for premier national institutes of India. Ashish Chauhanji has represented India in the International Youth Delegation to China in 2014 and has also been a fellow at the Legislative Fellows Program organized by Department of State, United States in 2016. He holds a bachelor's degree in science, a postgraduate degree in journalism and mass communication, and also earned his master's in business administration from the Himachal Pradesh University in Shimla. I request Ms. Pratishta Boro from National Law University, Assam, to come forward and felicitate Shri Ashish Chauhanji. I apologize for the mistake I made earlier. Sir has graduated from an LLB degree from the Faculty of Law, University of Delhi in 1999, and has enrolled as an advocate with the Bar Council of Delhi in 1999. I apologize for the mistake. I would now like to request Shri Vijwal Mangal Panditji to present the report on today's symposium.
Thank you so much. Good evening, everyone. Before starting, we have some introductions for the dignitaries present in the meeting today. I would like to introduce you to Shri Hari Borikar-ji, the Zonal Organizing Secretary for Akhil Bharatiya Adhivakta Parishad. Shri Pratik Sutharji, the formal national convener of Think India. Shri Ram Kumar Gupta-ji, the State Organizing Secretary for Delhi. Shri Vipin Unyalji, the State Joint Organizing Secretary for Delhi. Further, good evening to all the esteemed guests, scholars, practitioners, my dear friends, and honorable dignitaries present on the dais today. It is with immense pride and pleasure that I welcome you all in the valedictory session of the 9th edition of the National Symposium on the Landmark Judgments of 2025, a flagship event organized by Think India. This year, we had the privilege of having as the inaugural session being graced by the presence of Padma Shri C.S. Vaidyanathan sir, along with Additional Solicitor General for India, Shri S.D. Sanjay sir, and the Honorable Vice Chancellor for NLU Sonipat, Professor Dr. Viren Singh sir. We also had the privilege of signing the Memorandum of Understanding with the NLU Sonipat, which is a very proud moment for us. And another NLU added to the list of MOUs which we've been dealing with the national law universities of the country, across the country. We had the privilege of us to have an exceptional lineup of speakers for the sessions today, and the four significant judgments of the past year of the 2025 were discussed, starting with the in reference to the summoning of advocates who give legal opinion or represent parties during investigation of cases and related issues, which was addressed by Senior Advocate Vijay Hansaria sir, Senior Advocate A.S. Karni sir, and Senior Advocate Siddharth Dave sir. Further, the second judgment, the second session which we discussed was on the judgment of National Investigation Agency NIA versus Pragya Singh Thakur case, addressed by the Special Public Prosecutor for NIA, Rahul Tyagi sir, advocate on record on Supreme Court, Shri Ayush Anand sir. The third session which we discussed was about the 3-year judiciary judgment, which is the All India Judges Association versus Union of India, addressed by the Honorable Member of Parliament and former Judge Shri Mahin Singh Solanki ji. Advocate Sati Gildial ma'am, who is the standing counsel for the state of Gujarat at the Supreme Court. And the final session that we had, which was the fourth session, which discussed the judgment about in the reference to the assent withholding reservation of bills by the governor and the president of India, which was addressed by Senior Advocate Sanjay Ghosh sir, along with Sri Savan Yamanur sir, who is a partner at Denton's Link Legal. Further, now I would like to call the team of Think India Punjab to present the honorable dignitaries with the Virsa Chronicles newsletter, which is released every month, and it talks about the contemporary discourse, it talks about the contemporary topics across the socio-legal aspects and environmental issues related to the state of Punjab. Now, I would like to elaborate upon the technical aspect and report aspect of the कार्यक्रम that we had today. And happily, we had a total of 460 registrations this year, out of which 50 were on spot, 410 were done online. And further, out of the registrations, we had a participation of about more than 280 students. Around 300 students were there in the auditorium who attended the session. We had around 20 professionals who were advocates practicing in the field who were here to attend the कार्यक्रम. We had total of 16 NLUs participating with us, including NLU Sonipat, NLU Lucknow, NLU Prayagraj, NLU Assam, NLU Odisha, NLU Tripura, NLU Meghalaya, NLU Patiala, NLU Delhi, NLU Jabalpur, NLU Ranchi, NLU Gandhinagar, NLU Nagpur, NLU Visakhapatnam, and NLU Shimla. Further on, We had students from private universities as well, which comprised of 20 to 25 students. And we had a total of around 180 students who were from the central universities. The ratio for the participation of boys and girls was this year exactly 50%, wherein we had participation from both the ends. Further, sir, each session therefore offered a profound discussion and diverse perspectives, making this symposium an enriching experience for all of us. Thank you.
With the utmost respect and admiration, I now invite Ms. Archana Partak Davi to grace us with the valuable insights and address this esteemed gathering.
A very good evening to each one of you. I'm so honored to be a part of this esteemed gathering. Of course, the young students, a mix of young students who will become lawyers and the young lawyers themselves. I can see a few of the cases I meet every day in the courts. Learned Attorney General for India, Honorable Mr. Justice Sorab Banerjee, Sorab sir, the national convener, the national secretary of Think India, the other panelists on the stage. I have come to know, and of course the report is also there in front of us now, you have been hearing throughout the day the 4 sessions and very, very important landmark judgments which were discussed today by some of the very, very eminent speakers, lawyers. And we have seen that it was this time, it was a mix of senior advocates as well as some very young advocates, advocate on records, who were there before you to have their viewpoint on the cases. So these are all the lawyers who were either part of the cases or they were there when these cases were being argued in the court. I feel that whenever we discuss about the cases, we have to keep one thing in mind, that any case becomes a landmark only when it tries to see a particular situation from an angle which probably is based on the current situations. If a law which is as it is, let me just try to differentiate it in 2 phrases. One is law which is as it is, and the other is what it ought to be. Now, law as it is in front of us in the form of texts, in the form of precedents, and added with the procedure. Law which ought to be is based on the current societal norms, or, we say constitutional morality, social welfare, and a big part is justice. So there is a constant discussion which is happening in the courts on what the law is and what it ought to be. There's a famous quote by Martin Luther King Jr., and he says that injustice anywhere is a threat to justice everywhere. Now, through these constant debates which happen, we try to analyze how the courts come to a conclusion, whether when they deviate from the existing laws, what is the thrust or the main reason why they are deviating. And the reason that we see in the present context, if we just look at it with an example, the example of AI is in front of us. Now, say 25 years, 30 years back, no one ever imagined that there would be something called AI. You would just say 2 lines and it will give you the entire background. It will, have so many things which the human mind probably will take some time to process, but the AI gives you the solutions immediately. Now, this doesn't come with all positives. We have seen that because of the artificial intelligence, there are problems also which are coming. The people who are taking the AI and misusing them are a threat to justice. And that is why we have seen in the recent times, we have seen the courts, particularly these 2-3 orders that we have seen, the initial orders and now a series of orders. We see that there are orders passed by the Delhi High Court where, you know, the personality rights are now protected. Now, we never imagined that, you know, back 20 years back when we heard the voice of Amitabh Bachchan and we saw him speaking, we never imagined that somebody could create an exact replica, you know, the voice, and nobody would ever imagine that we would think that this is the actual person himself. So the courts then took over this, and now we have a series of litigations which are there just to have a control over their personality rights. One other example that I can give you are the John Doe orders, which are now passed in the IPR laws. Because earlier we always had cases which were X versus Y. We knew who the defendants were. But now is a situation that you don't know against whom you are filing a case. The defendants are not set there, you know, properly. We don't know them. So then now the courts are passing the John Doe orders, which are applicable throughout. So you get an order which is applicable against everyone. These are certain examples that tell us that why we are discussing what the law ought to be. Now, before even the laws were made, these judgments came in, the courts came into the rescue of people who were being misused, whose rights were being misused. That's how the courts, you know, go into those areas which the legislature also probably hasn't thought of it till that time and has not set out the laws in black and white. Coming over to the aspect of debates that has been a culture of our civilization from the times immemorial. Of course, ours, India being Bharat, being the largest democracy of the world, our entire system is based on debating. So the legislature makes the laws through debates. There is active debate which happens in the parliament. The executive then implements it. And then we have judiciary who analyzes these laws, who actually goes on deep in those laws, and sometimes when required, you know, they kind of deviate or they give their, you know, guidelines, trying to analyze and give it a detailed view what the laws mean to be. The dissenting judgments are again one of the important aspect of our law, how the law has taken recourse, and we have seen one of the most famous dissent in our Indian, you know, history of litigation is the Justice H.R. Khanna's dissent in ADM Jabalpur's case. Now, we always thought that dissent is something that that is sometimes very rude. But I believe that dissent is a safety valve of the democracy. It has a view which is different from the majority view, and we have seen that the dissent of the old times actually become the bedrock of the law which is to come in future. We have seen it in this present case. So where that dissent of Justice H.R. Khanna stood by the fundamental rights, at that time probably it was it appeared to be a very, very rude dissent, but now we see how important it was and how it has shaped our entire you know, litigation history. So we can see that it is very important that how the judiciary is on one hand and the lawyers on the other. They walk hand in hand and they try to have the best for the citizens of this country. We are two sides of the same coin. So your role as a student becomes very important because you are the future of this country. And I think what two, three important suggestions that I can give you when you are reading these judgments. You have heard these 4 judgments, discussion on these 4 judgments today, but it would be important if you try and read the judgments and not just the conclusion part, but read the arguments, because ultimately what comes down in conclusion is emanating from the arguments of both sides. Nowadays, we see this habit of, immediately coming to the conclusion and then seeing what the judgment finally upholds. But it is important to see what the arguments were and how they have been dealt with in the judgments by the honorable judges. So as students, you've got enough time. You should read these judgments carefully. You should also, it also enhances your skills, which would be very, very helpful when you become lawyers. Your drafting, your researching, all these things are very important, which you should keep in mind when you're reading these judgments. We have seen over the past few years that though they say that the Supreme Court is the final court of the land, but it's not that they can't commit mistakes. So while you have the judgment and then there is a review, even the Supreme Court felt that there is a need for leaving that little space where probably it comes out later that they have committed a mistake probably. So then a concept of curative petition was evolved through the judgment of Rupa Ashok Hurra. And the Supreme Court said that, yes, in cases where we see that there is something big has happened, which is against the laws or against the facts or the records which are there before the court, probably could not have been looked into earlier. So you have the concept of curative. So law, we see it's a continuous evolving tradition, and our constitution itself is a very fluid document, and that is why we've had so many amendments till date. So we see that whatever we are reading today, probably years to come, we will have some other version of it. So nothing is static, so is the law. And whenever you have some questions in your mind, and somebody tells you, oh, this is not, what you're talking doesn't make any sense. Maybe 10 years down the line, people would applaud you for having such a different idea and concept. So with that thought in mind, just let your mind be loose, think aloud, think what can be the other aspect of a particular judgment. Maybe you'll have your day in the court when you will be arguing to make that thought, a reality in future. Thank you. Thank you for inviting me over. Thank you very much.
Thank you very much, ma'am, for your inspiring words and for sharing your invaluable insights with us. Your guidance will certainly illuminate our paths as we embark upon our legal careers. Now, I invite Honorable Mr. Justice Sorab Banerjee to kindly address the gathering and share his thoughts with us.
Namaskar. Very happy New Year. I think all of you here know about cricket, watch cricket, dream cricket as an Indian. I'm lucky to be the second but last batsman. After having opened the innings in the morning with another opener, a serious, distinguished opener, followed by a battalion of good lawyers who acted as the middle order, I know as the last batsman, I just have to scrape through the final overs. So I'm happy to be here at the last call. Good evening to all the distinguished speakers in the dais and the distinguished guests of the dais a thank you, a big thank you to all those associated with Think India in all capacities. And I mean all, the directors, the staff, the helping hands, the personnels, the students. With them, all have a big role and a big hand to play for making this event successful. Since this is the last session, as they say, picture abhi baki hai. Not today, not tomorrow, but soon with another invigorating session of Symposium of Think India, 10th one. I know it will be soon. At the outset, congratulations and best wishes for the forthcoming ventures. I really look forward. Before saying anything, I must say, the topic for this session on landmark judgments is well chosen. It is involving, it is essential, it is constructive, it is directional. Without going into the aspects like Ms. Davi very categorically said, and she covered all the aspects and all, I just want to briefly say from the other perspective, all judgments are judgments. Why do we call a judgment as a landmark judgment? We don't write. We only write what we hear. It is you who make the judgments a landmark. You have to make, as was very correctly said, you have to make, let your thinking loose. The more you think, as I say, I only need a food for thought. Please think. Please think beyond the realm. I'll just give you a very nitty example. As she said, 20 years, 30 years. Earlier on, we used to have telephones. Ghanti bajti thi, we used to go there, we used to pick up, there was a cord, and you would say that, please come and receive the phone. Nahi aata tha, aapko phone ke paas jana padta tha. Nobody would have thought, matlab, phone chalega aapke saath? No, please, what are you thinking? As she said very correctly, I mean, you would have been discarded, but today you would have been applauded. That phone, then came the wireless technology. I think it had range for 1 kilometers or 2 kilometers. You could carry a handset. I don't know what it's called, what it was called, handset only. And you could talk, but not beyond 2 kilometers. But today, you have a mobile, a moving phone with you. You don't have to go to the phone comes to you. You can carry the phone, I know, I don't want to use, to the places you don't want to actually, but you have to. And knowing Indians, I'm also an Indian. If your phone doesn't ring, kuch ho gaya kya? Is something wrong? We don't realize that we are moving towards AI. Tomorrow we'll not have a phone. We'll have a button. Hello, how are you? You'll see 10 people talking in front of you. Well, today, if I see, I'll think that he's blabbering and apne aap se hi baat kar raha hai, itna hi jazbati hai kya aadmi? Mark my words, 10 years down the line, you will see no phones. You will have nothing. Earlier on, I'm so sorry to say, kids used to ask the parents, iska kya hoga, iska sawal ka jawab kya, iska sawal kya? The parents used to think, hame bhi padhna padega. You know what? I'm so sorry to say, you don't ask. Why? Does anybody have an answer? Simple answer. Google Baba ki jai. That is, I'm saying again, please remember, every judgment is a landmark judgment. But what makes a judgment landmark and what has made the judgments, the 4 judgments landmark this year is how they have been dealt with after, as she very rightly said, what was argued. I'll just briefly cut down to the judgments only, starting from the first landmark judgment with respect to the summoning of advocates who give legal opinion or represent parties during investigation of cases and related issues. What began as with the registration of an FIR, it's a common thing, and the bail granted to the named accused therein gave rise to a notice under section 179 of the BNSS, wherein the advocate was issued summons. There's nothing spectacular about summons being issued, but it was a case where an advocate had been issued summons. The High Court, upon challenge thereto by the advocate, declined interfering as it was issued by a competent authority. There's nothing, it's a well-written judgment. It was a well thought. This resulted in the Honorable Supreme Court taking the suo motu cognizance. That's where the landmark element starts. The Honorable Supreme Court has drawn a clear distinction between the process undertaken in summoning the advocate and the privileges enjoyed by him in a client-advocate relationship. Please remember, this was always there. This today also it is there. By examining the legality and constitutional validity thereof in the presence of various high-profile powered legal bodies like the Bar Council of India, the Supreme Court Bar Association, the Supreme Court Advocates on Record, the Honorable Supreme Court has drawn a clear distinction. Again, I'm so sorry to repeat myself, the landmark. That the Supreme Court, in fact, maneuvered between the various provisions relating thereto in the BNSS by upholding the rule of law. The Honorable Supreme Court was the summons received by the advocate, recognizing the existence of client-advocate relationship as sacrosanct by clarifying that being an advocate, but not an in-house counsel. I reiterate, it's good that Ms. Davi came before me. I reiterate, don't take a judgment on the face value. Don't read the head notes. I'm just sharing what I did. As an advocate, every law publication gives a head note. I'm so sorry to say, I never read the head note because I read the whole judgment. To accept what was written in the page 10, I should be knowing, and in fact, to face the last batsman, you should have faced the first to the last but not the least, the last batsman. Please remember to read all the lines. In fact, I'm so sorry to say, all the words. Each word makes a difference, makes a meaning, gives a new perspective, a dimension. It's like, you are good. I say it, but if I say, you are good, you are good, the voice makes a difference. When we write, when we read, you can't hear the voice. But if you hear what is being written, then you are giving yourself as good lawyers birth to a landmark judgment. So anyways, I keep on specializing, and using the word specializing, my aspect of a good lawyer. I keep on saying, I only write. लिखवाते आप लोग हैं. Please remember, I again say, the landmark judgments chosen, each one today, are a treatise. But I again say, this has all been successfully done because of the lawyers. again, coming to the second landmark judgment, All India Judges Association versus Union of India. Here, the Supreme Court dealt with the minimum 3 years experience of practice required for a candidate to be eligible for rendering judicial services, while noting the prevailing circumstances, including the views expressed by the various high courts across the country. And this is again what was said, the curative, the review. Taking note of the 2000 judgment rendered by the Honorable Supreme Court of India and All India Judges Association versus Union of India, which, because of the Shetty Commission report, because of a brought a significant change, the Honorable Supreme Court, after considering and deliberating thereon, along with difficulties faced for a period of 20 years, this was a case of 2002, this same came in 2022, has recognized that the first-hand experience of the working of the court system and administration of justice means a lot. In effect, the Honorable Supreme Court of India reaffirmed the equal requirement of 3 years experience of practice required for a candidate to be eligible for rendering judicial services. The third landmark judgment with respect to withholding of or reservation of bills by the Governor and the President of India under Articles 200 and 201, after negating the preliminary objections on maintainability. This was another, I again say, I'm so sorry. Please read this judgment. This gives a whole new perspective to what you, lawyers, can argue. The sacrosanct duty of the Honorable Supreme Court to interpret the Constitution, the Honorable distinguished with a role of governor from that of a chief minister, using the text rule of interpretation as also keeping in mind the democratic process and the federal scheme of the Union of India. The though I have to be careful when I use the words. Though not specifying a fixed timeline, it recognized a reasonable time frame for the governor to discharge his functions, as also emphasized the scope of judicial review by the courts in cases of prolonged delay. The fourth and the landmark judgment, like which we all know, the Pragya Thakur case, I would say, again, this gives a basis of analysis for the criminal law. The trial where the age-old principles involving actus reus and mens rea have been given due weightage. With that, I just think that that's enough. I'm in a position, I can't say anything more than this, but I wish all the very best to future in the gleaming new 2026. May you all awake, rise and shine to a fresh beginning of hope with clarity to give them meaning and shape. Jai Hind. Thank you. Thank you.
Thank you very much, sir, for bestowing with us your words of wisdom. Your insights have truly been enriching. I hope they will guide us as future legal professionals. Finally, with immense honor and respect, I invite Shri R. Ramani, Attorney General for India, to grace this gathering with his address.
I was reading a book recently. The title of the book is called The Call of the Siren. The siren was in Greek mythology, an island where if you get lost, right, and you heard something very inviting, and then sailors used to get inside the island and get lost. And it was said about Ulysses that he said, I must be very careful. I must not hear this voice, that my ship and myself do not get lost in the island. And what he said was how to be attentive, not to listen, right? Now, the attention part of our mind is something very remarkable. Even after 4 to 5 sessions of hearing people talking about several judgments of the court, if you can manage to be attentive to what people are talking at the end of the day, something very remarkable. I want you to, be attentive to everything in your life, right? Why do I say that? If you're talking about landmark judgments, we must begin with attentiveness. Before I talk about that, a couple of years ago, I was in US to attend a conference, and to go back to my flight, the cab driver engaged me in a conversation. And he asked me, where are you from? I said, so-and-so, practicing in Supreme Court. And he said, you know, sir, the US Supreme Court in Brown versus so-and-so. I was so surprised. A cab driver was talking about what happened in Brown versus so-and-so, a famous case about, segregation issues in US. I was so surprised to hear somebody engage in a conversation with me, with a foreigner, a cab driver, but Supreme Court of US doing what about segregation and racial segregation and all that. Then I begin to think that I come back in India. I suppose I engage in a conversation with an auto driver on what Supreme Court says in Keshavananda Bharati. I thought it would have been drawn a blank about it. So you talk about landmark judgments, we are talking about what courts do to appeal to the nation. Courts are talking to the nation. Judgments are discourses with the nation. Judgments are engagements with the nation. And why do they engage with the nation? Why do courts have to engage with the nation and the people? If judgments are ultimately a matter of an enforcement of an order, which government may or may not do, there's a very short and narrow way of looking at judgments. We talk about judgments as part of a national discourse, a democratic discourse, and a national discourse where the judgments and the court are asking people to think. So judgments are asking people to think. So therefore, why do you think and how do we think? So why do you think is one way of or address where the judgments talk about it, and how do you think is also a matter judgments ask you to talk about it. So how do you think, why do you think, and why at all do we have to think? So if judgments do not exist, like courts do not exist, imagine a country like communist China today, which has evolved in the past 20, 30 years after it became a different kind of a communist country from Maoist communist country. So if you look at the history of even a court in US, in China, communist China, the People's Court, right? How it has evolved over a period of time. And if you look at contrast what for more than 200 odd years, the US Supreme Court has been doing. And in 70 years, what the Indian Supreme Court has been doing. All that has been, and I think finally understand as a lawyer, that it is a matter of discourse of the people of a country. So if for 200 years, the US Supreme Court was talking about racial segregation, and see there are outstanding issues in US. And why is that so? Is it that the people of US have not been engaging in a useful conversation with themselves, or is something else? And we compare the 70 years of Indian constitutional history and what Supreme Court and High Courts have done to ask people to engage in a conversation. You go back in early 50s, who came to the High Court and Supreme Court? Very ordinary people. Right? You go to people who talked about right to trade, people who talked about a woman who came to Kaushalya, who came to Allahabad High Court, who said, I don't want an immoral traffic act to impinge on my right to practice, for instance, sex engagement. So very ordinary men and women came to Supreme Court and High Court regarding what? Asserting certain rights they thought must receive a certain attention from the nation. So if you look at all the recent judgments in the past 2 years, I only look at from that point of view. Is the nation receiving? Is the nation giving attention to what the court is saying about, talking about? We talk about the nation, we talk about the institutions of justice, we talk about the institutions of governance, we also talk about parliament. So I just picked up a couple of judgments in the last 1 year, about 75 odd judgments, and I found out also that about 40 to 50, I figured in some time or the other. But I'm going to look at why exactly we call them a landmark. Well, certainly I stand by the remarks and observations made by the Sorab Banerjee and Arja Partak. I think it's important for us to say that if the law going to be standstill, she said the difference between is and not, right? And there are a lot of writings about common law. I wish you all pick up a book written by Judge Holmes on common law. Read that book. And why, and then you go about how England talk too much about how common law gave birth to a most important pronouncements in English jurisprudence. And common law meant growth by judges, contributions by courts, not by parliamentary legislation. But then in a democratic country, I think all of them have to converge. No institution is superior. And then if constitution is the fundamental law for us to understand and then guide our nation's destinies, then every institution must play the independent and then a role which historically we talk about separation of power. I'm not getting into that question. Therefore, in democratic country where institutions must play their role, judgments have an important role in the sense it becomes part of our national discourse. You must understand that point of view. It is not merely something where an order is given, somebody must obey it, and so on and so forth. It's not, for instance, I remember in the early 83 or 84, as a young, lawyer with a lot of vision. So there was a demolition of a slum near my house. And I woke up in the next morning, read a newspaper, and women and children, shivering cold in December, photographs describing their, unfortunate condition. So I thought, what is happening? Why is that people should be deprived of their right to shelter in what is happening in this country? Delhi, I was so new to Delhi, right? 4 years in Delhi. Something told me that I must go to Supreme Court and file a petition. I filed a petition myself. I was a petitioner myself and said right to shelter. Right to shelter must be a fundamental right. And then soon thereafter, of course, much later when Volga Tellis came, the conversations became very, very vocal. So soon thereafter, I was traveling in Gujarat and doing a survey about schools in panchayat areas. And we are talking about a particular village, engaging in a conversation with the local people. The school did not have a roof. People were sitting without a roof, a good panchayat school, right? So we were engaging in a conversation with the local people, and they said, you come from, faraway urban cities, and what do you know about the plight of, rural schools in our country? And after some time, I thought, is it really that this is the kind of government schools in our country? And a year later, along with an organization working in Gujarat, we filed a petition in the Gujarat High Court saying right to education must be a fundamental right. Much later, it became a fundamental right. It's a constitutional right today. Well, how do ideas, therefore, generate themselves? You are attentive to a condition, a social condition, a social situation. If you're as attentive to as that, I think ideas come so creatively to each and every one of you. Therefore, the ability to create innovation, creatively look at your own conditions around you is what makes a good lawyer, I understand. So if you're not able to be attentive and not be able to innovative and create about your conditions you see around you, I think you are just a practicing lawyer. But a practicing lawyer is not what Think India wants. We want lawyers who must go beyond mere practice. Practice within inverted commas. Practice where you make a little money and be happy with that. But you want to think about being a lawyer, part of making India different, right? Making India different what the other countries are. You must be a different kind of a lawyer. And therefore, engagements like this are to be engagements in not merely looking at judgments from doctrinaire points of view. You're asked to look at judgment from their creativity, innovation, and making life different for all humanity, right? Now, I want to give a few examples like what I told you just now. I understand that courts have a role to play in national development. Every court, including Supreme Court and the High Courts, have a role to play in national development. And what is national development? And how do you link national development to the landmark judgments? If Supreme Court has said in the last year that it must be a law for domestic workers, is it merely a new thinking or a thinking because nobody has thought about it? Why not parliamentarians have not thought about it? Why not government have thought about it? Therefore, if I look at the judgments in the past couple of years, I find a certain trend. The trend is like this. You have lots of legislation, virtually every aspect of our life today. And there are certain aspects of life where no legislation probably deals with them. So where legislations have dealt with aspects of our life, courts begin to engage in fine-tuning them, giving more attention to what probably somebody has not even looked at. So we talk about a process administration, process improvement, process fine-tuning. Courts will have no difficulty in doing that. Whether you must serve a notice not through WhatsApp, but directly for Section 41A under the Criminal Procedure Code. It's a process fine-tuning. Or whether you should dispose of judgments within execution bid within 3 months or 4 months is a process fine-tuning. But they occupy a very small, narrow field where courts may not find difficulty. When you talk about issuing a mandamus to the parliament or the government to say, enact a law like this, what does it mean? It means the attention which the nation has not paid so far to a particular issue. You have issues about domestic workers, issues about Safai Karamacharis. So those men and women who are not probably looked at more close. Today morning, I was in a function celebrating the World Braille Day. So the Braille is a tool which liberated blind, visually impaired people from all that could never been happening to them. So the tool, such a tool, so how should law protect and promote that tool? There are tools and tools of human creativity which are available to us to look at very more closely, and how do you therefore enhance the availability, the accessibility, if we talk about access to education. So look at the disabled person, the visually impaired person. What kind of access do you have to education? So in these areas, if judgments occupy a space, then they become landmark judgments. They begin to create a new way of looking at life, a new way of looking at life, a new way of asking you to pay more attention to what people do not pay attention to. Therefore, I would probably look at you to, when you pick up each one of the judgments, please look at them from this point of view. Have they made, are they proposed to make life different from what it was? So if life is not made different from what it was, then what use of judgments and courts and institutions and parliaments? What use of democracy? The democracy ultimately must mean today. And whenever I go to law schools and give lectures, when students ask several questions about right to freedom of speech and expression, I ask them, would you like to go and live in communist China? Many of them, I ask, those of you who would like to say, put up your hands, I never see a hand being put up. The reason, probably you're not understood why you're not putting up your hand. You must understand why you're not putting up your hand. We are talking about liberty, freedom, right? The liberty and freedom which each and every one of us would cherish and value uppermost in our life. All of us are creative, all of us are innovative. We create something other in our life. And without the innovation and the creativity and the freedom to innovate and create, life is meaningless and worthless. But for a large one of us, I know people who are able to access education, other resources in life, we are fortunate. But there are large millions and millions of countrymen and women who are not able to access them. Therefore, the role of the courts and parliament certainly is to ensure that all those resources which makes life wonderful, meaningful, and fulfilling must be made available, must be made accessible. That's where I think if judgments make a difference, they become landmark. It's not merely a question of looking at with a new point of view, but the new point of view must make a difference to lives of people. So when Maneka Gandhi said something about everything must be fair, just, and reasonable, it made a world of difference between A.K. Gopalan and Maneka Gandhi. What world of difference? Now we all talk about everything about our law must be fair, just, and reasonable. The process fairness, the substantive fairness. So that became a landmark judgment. Therefore, when you talk of landmark judgment, you must look at how the content and the way of looking at a particular issue has made it different from what it has been earlier. So pick up all the judgments which was delivered by Supreme Court last year, either in the field of arbitration or in the field of freedom of speech or in the field of freedom of expression. Look at every one of them. Every one of the judgments has made our perception about life, our perspective about what should be, has it been made different? Ask this question. When you ask this question, you'll be more attentive to what I say, being attentive to the surroundings of your life. The attentive part of it, I think, is more important for a student of law. If you're not attentive, I think you're just reading a judgment or just reading a statute, and then maybe you will help me by artificial intelligence in due course of time. And I am not fascinated by artificial intelligence because I think the human brain which nature has given to us is the most wonderful thing to happen in our universe. And why should we lose the value? Why should we lose the value of the wonderful intelligence given to us? So I keep thinking about it. I also write about it. And recently, when I read an article about Mustafa Sulaifa, he wrote a book on the new waves of artificial intelligence. So we are living today in a new machine age. A new machine age is very different from the machine age which has gone ahead. When combustion engine was discovered, right? World was different after the combustion was discovered. So also when we discovered so many other inventions in technology, they were in a spatial, the world of space. But the current machinery is not about space, it's about mind. So it's occupying our mind. And I was so fascinated by looking at how the tech giants, which have overtaken our world, Facebook, Amazon, Flipkart, so call any one of them, they have overtaken our mind. They have overtaken our understanding of how we'll do our transactions. So please pick up a book written by a New York bestseller called A World Without Mind. Are we going to be a world without mind? Or therefore, what will courts do to ensure that our minds are intact? Our intelligence is intact. Our ability to think is intact. Therefore, the courts have to play a big role in times to come. When the courts recently, Supreme Court said last year, no, we will not ask Wikipedia to remove something from from a defamatory statement. It is for Wikipedia to be responsible. I do not know how tech giants can be responsible by themselves. Therefore, the responsibility element, who is responsible for what and for what reason and to what extent? A big question going to be in times to come. For responsibility in governance, well, fine, but responsibility in the social media. So how do you therefore look at freedom of speech and expression in times to come? New ways of looking at them, new challenges, ways by which we do not know how to regulate. Therefore, if you want to talk about landmark judgment, look from all these points of view, and you will be rewarded. You will be really rewarded. I feel rewarded when I look at them like that. I feel very happy when I look at a judgment, not from here, reading a paragraph here, a word here, but looking at what does it want to convey, and why does it want to convey this, and has it really been successful in conveying a particular message? I think that's the way you should look at a judgment. Why does it want to convey? Has it been successful in conveying it? And you become a critique of that. And you don't become a critique of that, your way of using your precedent will be, I think, very deficient. When you become a real critic, you will use a judgment and a precedent in a very effective and a creative way. It requires a lot of, I call attentiveness. So attentiveness is, we are losing our ability to be attentive. Please don't lose them. The ability to be attentive is something so fundamental, so valuable to us. So I would appeal to all of you that when you discuss this kind of discussions, must be so invigorating to make you feel that you're part of a great journey in our great nation's destiny in fulfilling our egalitarian goals. So when you're feeling part of the great journey, I think nothing stops you from being fulfilling. Nothing stops you. And so I'm happy to be here with you today evening. And recently I was talking to Niti Aayog on how judicial contributions can be relevant to national development. I was looking at it from this point of view because we look at judgments from an entirely different angle. And I think it's important that for students of law to look at the role of the court. The role of the court today is very, very different. It is not what it was designed to be. As far as, let's say, the Englishman gave us some idea of adversarial courts. But we're not talking about adversarial court in that sense. We're talking about the role of the courts in a very fundamental way, fundamentally different way today. And once you understand the role of the courts in a fundamentally different way today, as a participant, as a deliberative mechanism in ensuring and enhancing social discourses, then you'll understand the importance of judgments. Otherwise, you say you will be probably part of some practice of law. I wanted to go beyond that. So having said that, I would not take your time much beyond that. But I just wanted to read for you, since I am so fascinated by this little instrument, which probably seals a good part of our mind. I was traveling somewhere two weeks ago, and I wrote this piece titled On Modern Theft. What is modern theft? Let me read it. What is modern theft? Jesting Pilate, I know those are Christians will know, jesting Pilate was a Roman general who asked Jesus Christ, what is truth, and would not wait for an answer. That's a biblical statement. So you would not want Jesus to answer what is truth. So jesting Pilate is that. So jesting Pilate may now ask, what is modern theft? Freedom is now leisure. The leisure that is mortgaged to web, internet, and a catalog of many things. On screens, little or big. And leisure is freedom. To scroll from morn to night, to be lost in someone else's world, made for money or jest, talks, podcasts, channels, earning subscriptions on pretty shows of entertainment in glitter and loud TV rooms, fashioned all to steal our time, as to fill, as if to fill our leisure with benign thoughts. Theft, theft, don't you doubt? Self-employed editors of all news, selling attention spaces as we pundits of daily truths, stealing the wealth of our mind. We feel you knowledge good for life. Ignorance is not bliss, they say. Minds forever in search of logged in things is surrender without resistance. To be alone in one's thoughts or mind, the wealth of knowing and being, the beauty of not wasting the mind as wealth, is now banned by machines of kinds new and engineers of mind, holier than old prophets of kind. The brave new world we wander long is freedom not nor leisure true, but a world without minds in search of freedom lost. I wish we don't lose our freedom. We're part of our freedom, a greater freedom, whereas lawyers we can contribute to a greater contributions by courts. And I think therefore it's important for us to be not lost in the new machine age, but to be able to be masters of machine ages. We talk about that, be masters of machine ages. And be masters of everything we need to about destiny. And we can do, lawyers can do that. And lawyers need to do that. So I thank Think India for engaging in this continuing conversation. And I'm sure we'll become richer in due course of time with the march of the nation's destiny. Thank you so much.
Thank you very much, sir, for your profound words and invaluable guidance. Your insights on the law and justice system will serve as a guiding light for all of us present here. I would now like to invite Shri Ashish Chauhanji to kindly address the gathering and deliver the concluding remarks.
Respected Ramani ji, Honorable Attorney General of Bharat, Justice Sorab Banerjee ji, Honorable Judge of Delhi High Court, Adaniya Archana ji, Visual Convener of Think India. I have a very difficult duty, and somehow that could have been planned, averted earlier. I have been asked to give concluding remarks. Part of me, as former convener of Think India, I can graciously present my gratitude to all the speakers before me, and part of my duty, which is to conclude today's conversation. It goes with the journey of Think India itself. When we actually started this Think India, it was way back in 2007. When youngsters in Bengaluru, they had a conversation that people are thinking of studying abroad. People are thinking of getting into top-notch institutions. Whether conversation about Bharat, conversation about our own country for its development, whether the idea of brain drain, can those ideation be brought back to Bharat? Can those ideation have Bharat at the center of conversation? That was the key conversation which drove students from NLS Bengaluru, IISc, IIM Bengaluru together, and they hosted first Think India convention in January of 2007. Sometime great ideas, great events, landmark events, you kind of initiate, and then with the glee and glitter, you somehow settled, and it goes into in a cold. And for 3 years, we didn't do anything after 2007. And it was only in 2010, a conversation started that we must again bring back that idea which was initiated in Bengaluru. And conversation happened here in Delhi University. And subsequently, 2011, there was a small event in order to just restart the conversation in Pune. And the journey started henceforth in bringing the IIT students, IIM students, National University students, I remember 2012, we were there at Indian Institute of Science, and students from IITs, IIM, national universities, they were deliberating about Bharat's future, and they were having conversation of vibrant India. I remember there was the first ever Think India law event. It was hosted in 2012. As Ramani ji, you mentioned, there is this limitation to our ideas. And whether a lawyer who thinks about freedom of expression, many a times, the activism, the activist part amongst youngsters on college campuses, we try to raise so many slogans, but reality is far deeper, far greater, and it has huge impacts on society at large. So we took the topic whether law is fulcrum of change. And when we drafted the statement, the first Think India convention, and I remember Aditya Srinivasan is sitting in front of us. He was the convener of first Think India summit there. This very idea whether law in itself represent the entirety of that change, but very humbly we presented a question mark and we stated that whether law is fulcrum of change. Today, when we study international law, when we study international relations, diplomacy, and we see incident of yesterday, which was broadcasted live on the X, none other than the President of the United States himself, we understand that the things which we read in the international law, international diplomacy, whether in the subject itself. I was having a conversation with the Oxford King's College alumni who is in international relations. And we came to a conclusion that international relations should brought back to the very topic which was back in 1920s and before that, the war studies. It is invariably the very subject. But end of the day, all of us, when we are coming to these kind of conversation, the landmark judgment, I would urge all of us that the series of 9 events happening every time at the very venue of the Prime Minister Museum and Memorial Library, happening on the very certain date, that is first Sunday of the January, so that it can express and have conversation about the landmark cases of the past year, and with exact same crowd, that is the youngsters, students from the national law schools, national law universities of whole of Bharat, practicing lawyers, professionals, some member of faculty, law professors, some members from the bar and honorable judges sometimes. It represents in many ways another festival which is going on along with these very dates, Magh Mela. Sometimes it is called Kumbh, and once in 12 years it is called Mahakumbh now. It happens on a very certain set of dates. It happens in very certain place, and it brings the sannyasins, followers together. Here it brings the lawyers with their dark black robes, black jackets, and what it can teach to the League of New Lawyers is that when you can show up every morning at 10 a.m. at the local court, learn from the seniors, argue in the court, prepare yourself. If the court starts at 11, you can have a time earlier, do your homework. This discipline can actually build you in that legacy. If an event can be a successful event, it can create legacy. It can allow even the media people to discuss it on their forums. Certainly, any youngsters who's thinking of starting their career in the legal domain, if they can be diligent in their working, success can't be very farther away from them. Many a times it is said about legal career, sir, कि जब तक आपके बाल सफेद नहीं होते तब तक आप अच्छा कमाते नहीं हो. But I can say youngsters with so much of knowledge, so much of experience when it coming from diversity of fields, technology, data, information, not only the AI, but the other facilities of the internet. It has allowed them to learn from so many references, so many areas. Earlier people, if they had to search for the judgments of the British courts or for the American courts, they had to rely on the books only. But the internet had allowed us to go through those judgments very easily. AI obviously is a very serious discussion, but there is an ethical conversation, ethical use of AI. And within the education realm, the conversation is that, yes, you can go through the AI, you can read the articles, reports, but when you are drafting your thesis, when you are drafting your petitions, you must detach two sets of the things. And many a times, youngsters, they are, if you can practically ask the young lawyers and students, they are invariably using AI. But if they could train themselves, discipline themselves, that the ethical use of AI should be allowed. And in that sense, it would pave way for new journey with artificial intelligence in all of these aspects. One of the points, Ramani sir, you raised is how your own journey actually allowed some of the key changes in Bharat. As a office bearer of Akhil Bharatiya Vidyarthi Parishad, I remember two instances when young people of Bharat, students, they came together and they argued that there should be a change in the date of age of voting. Back in 1971, Akhil Bharatiya Vidyarthi Parishad in its Adhiveshan, it raised that the age of voting is 21, it should be lowered down to 18. And that conversation for 1971, it continued in various forums, programs, activities. And in 1986, it was finally taken up by the government of India and the age was lowered. Secondly, in National Executive Council of Akhil Bharatiya Vidyarthi Parishad in 1986, we proposed a resolution on right to information, and that Suchna Ka Adhikar. And in Mysore NEC, that one resolution, it was adopted. It is there in our records. When I read it, and in reference to the Right to Information Act 2005, we understood that these kind of conversations were happening amongst college students, and that's why Akhil Bharatiya Vidyarthi Parishad adopted that resolution. And when we are in front of young lawyers, students, I think all the dignitaries have asked all of us to think out of box, think loose, and if we can think aloud in terms of all those ideas and passionately stand for the views which are justful, I think the journey of landmark judgments, it will go further. और जो लक्ष्य लेकर के थिंक इंडिया ये कर रही है, जो आइडियाज लेकर के ये कर रही है, that is for Bharat, that is for India. And end of the day, our journey, our event, our success, it would only mean when we are able to create newer avenues, newer examples for bringing Bharat further. Dhanyavad. Bharat Partak ji.
Thank you, sir, for your invaluable words of wisdom and guidance. Lastly, I would now like to invite Shri Vijwal Mangat Pundi to deliver the vote of thanks.
While concluding, I extend my heartfelt gratitude to all our partners who have been the backbone of the event. Starting with the knowledge partners, we collaborated with National Law University, Sonipat, along with Indian Law Journal Block Publication as the knowledge partner, along with the print as the media partner for the event, wherein the print was live streaming the event in their own media spaces. Further, we had All India Reporter as our knowledge partner and Mohan Lohaus as our merchandise partner. I humbly thank the honorable dignitaries, speakers, participants, and the attendees for gracing the event. And I am sure and hopefully confident that today's session will inspire some meaningful dialogue among the youth and the students that are present among us, and foster intellectual growth and provide a valuable insight into our evolving legal system. I hope you all thoroughly enjoyed the sessions and engaged with the vital discourse, which were important for for nation building and development of Bharat. Thank you so much.